What else? All
Right, yeah, we're gonna try to get going, everyone, just because I know time is valuable and it's sort of the end of the work night, so probably have some time after as well. But introduce myself, my name is Ryan Collins. I am the current chair of the City of Bangor's Board of Assessment Review. We're here this evening for an administrative hearing to consider the appeal of Fresh Start Incorporated. This appeal this evening will concern the denial of an application for exemption from property taxes for this entity's properties in Bangor, Maine. These being the following: 52 Blackstone Street. This is labeled or designated by the city as account number 111, tax map location 039-104. In addition, 38 Cattell Street with account number 8639, tax map and location 026-008. Next will be 117 Grove Street, city account number 9084, tax and map location 048-067. Next is 31 Highland Avenue, city account number 6324, tax and map location 032-095. Next is 89 Ohio Street, city account number 10548, tax and map location 033-079. Next is 326 Ohio Street, account number 5303, tax and map location 021-045. Finally, 115 Walter Street, account number 490, tax and map location 035-002-B. These hearings traditionally proceed in an organized fashion, so I'll be working off sort of an outline this evening. The idea is that this hearing procedure is identical to that we would use for any other administrative hearing that this board may participate in. So we'll open this evening with what I'm doing, which is sort of a statement of the issues and sort of the retelling of some of the basic facts of the case. From there, we'll move into an opening statement from the petitioner, should you like to make one, followed by the presentations of any witnesses or exhibits that you'd like for this board to consider. From there, we'll move to an opening statement from the respondent, which would be the city, if any, again, don't have to make one. Followed by a presentation of witnesses and exhibits. From there, we proceed to a rebuttal from the petitioner, followed by a rebuttal from the respondent. Finally, we move into argument by the petitioner, then by the respondent. And finally, after all of that, we have some basic deliberation and decision of this board, meaning a vote, essentially, in which way we're going to go. I will just mention procedurally that after a witness, if selected or called, has made a presentation to this board, we do have the ability as members of this board to ask questions of that particular witness, just to clarify a particular point or expand upon something. More than anything, just so we have really clear understanding in terms of what we're receiving. So the composition of the board this evening, I'd introduced myself, Ryan Collins as chair. To my right, we have Mr. Dean Beaupain, who is a regular member of this board, will be participating this evening. Opposite him, we have Mr. George Burgoyne, who's also a regular member of this board, will be participating this evening. On my left, we have Mrs. Jackie Bennett, who is an associate member of this board. However, she will be participating in this evening's proceedings and discussion in the absence of a regular member of this board. And all the way on the left there, we have Mr. Philip Cormier, who is a regular member of this board, will be participating. And we'll just mention, per the board's bylaws, a quorum of this board is present at tonight's administrative hearing. Are there any immediate objections to the composition of this particular panel by either the petitioner or respondent? Okay, beautiful.
I have one point I should bring up.
Sure.
I have sold 5 of these buildings to Scott. And if there's anyone that feels that's a conflict, I've represented them as a buyer's agent. And I just think that you should know that I have some relationship with Mr. Patti.
Okay. Just looking at that briefly, looking at, ethics disclosure and the like, you're not presently acting as an agent for the petitioner. I don't see an immediate concern, but I will open that up for discussion among the board.
Well, just to ask the obvious question, do you think you have you think there is a concern?
No, it's really a point of disclosure more to me.
Okay.
That I just want to put it out there that I know this guy's name and I know his laugh, I know I know a lot of good things about him.
Kind of a
so-
casual business relationship, okay, sure.
That seems reasonable to me.
Okay, I don't know that we need a formal motion to proceed, but considering discussion, we'll allow Mr. Cormier to proceed then with our hearing this evening, and certainly appreciate the full disclosure. Mr. Cormier just trying to avoid an issue or an appearance of an issue at a later date, so thank you for that. Housekeeping items, our hearing this afternoon, evening is being recorded. That being said, of course, only one person should be speaking at any one time, and for that reason, we have sort of an area microphone up here at the table, so we don't have microphones that we're trying to turn on and off. But that being said, if we could keep background noise, of course, to a minimum, that is certainly helpful as well. So we'll move into sort of some of the issues that are before this board this evening. I think primarily this evening, we have a question of jurisdiction, plainly. So does this board then have jurisdiction to hear the denial of an application for exemption from taxation now under Title 36, Maine Revised Statutes Annotated, Section 843? From there then, we would consider if these applications for exemptions were timely filed in accordance with Title 36, Maine Revised Statutes Annotated, Section 652L. That is the case, then we need to determine if Fresh Start Incorporated would qualify for a real estate and personal tax exemption for the properties that I just listed, which would come under Title 36, Maine Revised Statutes Annotated, Section 652, 1A, B, C, and J. Okay. Some general standards for evidence this evening. Any evidence tonight that has some kind of reasonable probative value will be admissible to the board. We'll deal with the pre-filed exhibits here momentarily. I will mention, just there is counsel in the room. There is really no technical rule of evidence or courtroom, for example, procedure. It is an administrative hearing in nature. I am not a judge, for example. But any evidence anyway is subject, of course, to due process where we had pre-filed materials. Any immaterial, irrelevant, or repetitious evidence would be excluded by myself. So in other words, if we've seen it once, feel free to refer to it, but we don't need it then submitted again. So next one here. Are there any preliminary matters that either of the parties would like to have the board deal with at this time prior to the admission of the pre-filed materials and proceeding with presentations? Beautiful. Okay, well, I'd entertain then a motion that we accept the pre-filed materials of the petitioner and respondent
So moved.
before this hearing. Great. Is there a second?
Second.
Beautiful. Moved and seconded that we admit the pre-filed materials from the petitioner and the respondent. Those were shared with the board members via mail and are generally in front of us, dated May 10th, 2024. Any other discussion? Great. All those that are voting are here physically present. So those in favor, please signify by raising of the right hand. Down hands, those that are opposed. Beautiful. Okay, so pre-filed materials are admitted and will be considered this evening. We will proceed to the presentations. Mr. Chairman. Mr. Vice Chairman. Oh, yeah, we'll swear thank you. Okay, at this time, the petitioner, Mr. Party, would you please identify any of the witnesses that you may be calling so that we could swear them?
I'm not, I don't have any witnesses.
Okay, will you be offering direct testimony yourself?
Yes.
Okay, I think we could swear you then, so if you would, just please rise.
Yeah.
Oh, yeah, and then the respondent side, Ms. Collins, witnesses for this evening?
Just myself.
Yourself, okay, sure, if you would then, please rise and we'll run right through that. Okay, I have to ask you if each of you solemnly swear and affirm that the testimony which you are about to give in the matter now in this hearing shall be the truth, the whole truth, and nothing but the truth under the applicable penalties of perjury.
Yes.
Beautiful. Please be seated. Thank you. Okay, we'll now proceed, as I'd identified earlier, with the hearing, primarily with the first question, which is, does this board have jurisdiction to hear the denial of an application for exemption from taxation under Title 36 MRSA Section 843? So as a part, of each party's presentation, please directly address this board's authority to act on this type of denial when Section 843 provides jurisdiction to the board over abatement denials, not exemptions. So we will move to the presentation from the petitioner. Mr. Party, the floor is yours for you to highlight anything you see fit.
Come up to the podium, or I can do it here, or?
That's probably the microphone.
Recorded, so.
Oh, it's being recorded,
Yes,
okay.
yes.
My name is Scott Party, I'm a resident of Bangor, I'm the executive director of Fresh Start, which is a newly formed or transferred from a subchapter S to a 501c3. Everything has been taken care of. We filed the papers with the IRS on August 2nd of last year. The IRS had their self-proclaimed time limit was 180 days. They missed the 180 days, but there's no repercussions for the IRS. You know, that's just, if they miss it, they miss it, and too bad for you is how they generally proceed this. And so I've been, the actual 501c3 was mailed, was postmarked on April 11th, and I did not receive it for several days after. I came down and met with Phil Drew in person to see what we had to do to do it. He was very helpful, very nice man. I have nothing bad to say. I have no qualms with the evaluation of the property. I totally, agree with it. And what I'm asking for is to have this looked at, backdated to April 1st. Now, of course, the major reason that I need this to be, you guys to look at it as April 1st is because the tax burden is extreme for Fresh Start. Fresh Start has not raised any of their rates since we started, which was 6 years ago. And with that being said, we all know what energy costs are today. And I don't know if you're all familiar with what Fresh Start does. Are you, or?
Please, you could expand on that just to ensure that we're all on the
Fresh
same
Start
page.
was formed in 2018 and became a subchapter S corporation in 2019. Fresh Start started by me going into the jail, Penobscot County Jail. I'm a person in long-term recovery from drugs and alcohol, and part of my duties is to go into the jail and bring recovery meetings, and I've been doing that since 2014. And I saw the recidivism, the revolving door of people wanting to come in and out of, not wanting to, but ending up in jail, having to go back to being released from jail, having to go back behind the Hope House or to the streets or wherever. And of course, the years of doing this, you get some sort of relationship with people doing that. And so I finished paying off my own mortgage, and I bought a house on Ohio Street, 87 Ohio is the first house. I said, well, I'm going to give 6 people a place to stay. They're going to have to pay, and if it doesn't work out, I'll sell the house. But I don't have a mortgage payment, so I can do that. So that's how it started. It exploded from there. Today we have 16 residences, two. One is, we leased one from the Bangor Area Homeless Shelter. We leased the other from the Bangor Area Recovery Network in Brewer. And I own the first 5 houses personally that I leased to Fresh Start. All the houses that you see here were deeded to Fresh Start after we were able to establish some credit so the bank would lend Fresh Start money.
Can I interrupt you for
Sure.
a second? Did
Yeah.
you say that you personally own the 5 properties?
Not these properties.
What's that?
Not these properties that are listed.
Okay.
We have 15 houses. I own the first 5 because Fresh Start had no credit, and the subsequent houses you're looking at are all deeded to Fresh Start.
Can I ask you another question?
Sure.
do you think that an application for abatement is the same as an application for exemption?
No, I'm not looking for abatement at this time. I'm looking for you to backdate or allow this to be seen as filed on April 1st or however you have to do it.
Well, that's a question that we're focused on right now.
Mhm.
You didn't file an application for abatement, you filed an application for exemption.
Per Phil Drew.
And the question is whether this board has jurisdiction to hear your case
Yeah,
because it's a denial of an exemption as opposed to a denial of an abatement.
okay, now in the papers that Phil had given me, and he went over with me, we are qualified for exemption. He says clearly in here that, I can't tell you exactly where, but that we are qualified to be exempt. And with that being said, and there's no tax bill as such for 2025 or 24, what is the one that starts in July? Is that
FY '25.
FY
We haven't gotten
25?
that bill yet.
Correct, which I don't have that bill yet, and that is why I'm not looking for an abatement. I'm looking to have you examine this as, because we were held up by the Internal Revenue Service for all of this, I'm looking for you to make the adjustment to backdate it, or allow it to be backdated per what Phil Drew had asked me to do. So I do know the difference, and it's more of a date thing than anything. And if we have to, I think that you folks certainly do have the authority to do that.
And why do you say that?
Because I think it's clearly states in some of these that you have the authority, but I didn't do it all, because I'm not a lawyer, believe me, that you do have the authority to look at this, and where it is date-driven, it says the law of court is referred to April 4th as the doom day, as it fixes ownership and tax liability. So that's what I'm asking you to do, is to allow it to be backdated to April 1st. So it's not an abatement, and the exemption hasn't been denied. Phil clearly states that we qualify for an exemption. Am I doing this right? If I'm not, tell
But
me.
you're trying to answer the question. We're just, part of this,
Yeah.
as we said, is we can clarify with you,
Yeah.
just so we understand fully
Yeah.
your position. So you see us taking some notes, obviously
Yeah.
trying to do that.
No, yep. Does that help?
Well, you stated your position.
Okay, yep. And I forgot where I left off, but anyway, so I think was giving a history of Fresh Start, which
Well,
we don't have to have, you know?
that's kind of like the third question tonight. We're on the first question. And the first question is whether we have jurisdiction to hear the denial of an exemption. Because the statute says we hear appeals of denials of abatements.
But it's not a denial. I'll have to refer this to an attorney, I think. And there's one right there. It was denied because of the date.
Right. But it was definitely denied, wasn't it?
Correct, yes.
Okay.
Yep.
Well, do you have anything further to add on the question of our jurisdiction?
No, but does that make sense that you do have jurisdiction because it's a date thing of the exemption? It's not anything else but the date?
Well, we have to hear from the city, and then we need to decide that question.
Sure. Okay. Well, if you're done with history of Fresh Start, if you want more, I got more. If you're good with all that.
No,
Mr. Pryor, I just have one question. Were all of these properties transferred to Fresh Start before April 1st of this year?
All the properties were owned by Fresh Start. They
Prior
were
to
deeded
April.
to Fresh Start before.
Okay, thank you.
Now, these are the ones that are in the Fresh Start
Fresh deed to
corporate,
Fresh Start.
corporate identity.
Correct,
Yeah, okay.
Deed-
So you're only taking the corporate ones
correct. Yep,
through
exactly.
the, through the media of
Right.
non-exempt.
Mr. Drews did tell me that the ones I own personally aren't exempt. The only way they'd be exempt is if I deeded them over to Fresh Start, which I haven't done yet, and I'm not sure I will do that. I just don't know yet. So, no, all these properties are the ones that belong to Fresh Start, are deeded to Fresh Start.
I read all those deeds, so I know they
Yeah.
did go to Fresh Start.
You do. Have I done a good job? You done with me, or?
I, provided there are no other questions, and again, we could come back to it. I mean, I
Yeah.
think we're following,
Yeah.
the position
Yeah.
that you've offered anyway for tonight, so.
So it's essentially just a date issue is what he's asking us for, due to his delays with the IRS.
That's the second issue. This issue is whether we have jurisdiction under our statute to hear an appeal of a denial of an exemption as opposed to an abatement.
It is a denial of exemption by date.
Well, we all agree it's a denial of an exemption.
Yep.
No question about that.
Good. Okay, well, we will appreciate it, and we will proceed. And again, we need something further, we can get it. Thank you. Okay, at this time, we will switch to the side of the respondent. Could we have the opening statements and associated witnesses?
Hi,
Oh, hi.
I'm David Sepchek. I'm the city solicitor of the city of Bangor. At the table with me tonight is Peggy Collins from the assessing department and Grace Innes, the assistant city solicitor. And just to address the jurisdiction issue, a taxpayer has two avenues to seek an appeal if a tax exemption is turned down. One avenue would be to file a civil action in court seeking a declaratory judgment that is tax exempt. The other avenue is to file an abatement application with the municipality. And then if that abatement is denied, to appeal that abatement decision to this board. And unfortunately, there's no other jurisdiction that is available for the taxpayer to get in front of this board. The statute that was mentioned is 36 MRS section 843. That's for appeals of abatement decisions, and that unfortunately doesn't apply here. There's there's case law on this, and abatement proceeding is the proper vehicle in which to challenge the taxation of property claimed to be exempt, and that would be Maine Central Railroad versus Town of Dexter is the case. Kind of a related way of saying it is that this appeal that's in front of you tonight isn't ripe, because it's Mr. Party and Fresh Start, they would need to wait until they receive the tax bill from the municipality, and until he's denied an abatement application with the assessor. Not saying that he would be denied, but if he were denied, then that would be when he could bring an abatement appeal to your board. So unfortunately, at this time, there's no jurisdiction for this board to proceed. The matter's not ripe. And as far as that issue, that's all there is to say on that issue. I'd like to field any questions if you have any.
So just to clarify, and I'm assuming, but you're referring to our enabling statute, which would be, Title 36, Part 2, Chapter 105, subchapter 8, subsection 843, where it talks about, our scope, so to speak, of review is specific to an abatement request. Is that the, okay,
That's right, 843 subsection 1.
one, yeah.
Right.
Can I ask a layman question?
Sure.
I mean,
Which we do have.
then on an issue like this, who should get it or how, yeah. I don't, he had a filing date that he didn't file on. He missed, through, I guess, no fault of your own, as I understand it. And that has a certain consequence for this tax year, and evidently I was in the reading that the request to have an exemption or whatever was granted for 2025, if I read this right. So and you're nodding your head, so I assume that means in my plain English is that addresses your issue. In 2025, the problem is it's 2024 now, and what you're trying to do is address it in '24. Or am I wrong?
No, it says,
You probably should be at the podium.
Okay.
You're going to speak so that
yes,
the recording can hear you.
yeah. I was told that, in here, that Phil had done, the city recognizes Fresh Start Inc. as a nonprofit. The entity meets the statutory requirements as outlined in Title 36, Section 652 of ownership and use, but does not timely file its application with the local assessor by April 1st. The application must be denied. The written exemption application was filed by the city assessor on April 29, 2024. Again, for exemption application to be considered for April 1st, 2024. The completed application must have been submitted by April 1st. After my review, this entity does not qualify for the tax exemption as of April 1st, 2024, but will as of April 1st, 2025.
Yes, that's what I was referring to.
But-
So I understand we got a problem.
Wait a minute, now, has the exemption been granted as of April 1st, 2025?
Yep,
It will,
It hasn't yet.
well, yes, his
You
application,
want to step up to the mic?
Yes, please begin with the mic.
sorry.
You're in a unique circumstance is the short
Yes, his
answer.
application that he filed, the
Right.
one for this year, I believe was denied.
Right.
But he is eligible for that exemption.
Does he need to file another application?
That Phil did not tell me whether
Well-
he did or not. I believe he's going to assume that this one is good enough for 2025, because he has told him that he is approved for.
Right, but if he
2025.
doesn't file that application, he won't be granted an exemption, will he?
For 2025. For fiscal year 25, which is 2024, he is not eligible for that
Right.
exemption.
Right.
But come 2025, he is.
If he files an application?
I think this application, it sounds to me like Phil has accepted that for fiscal year, or for 2025.
That was my understanding when I read it, that's what
Yeah.
I assumed it was.
Right.
So that's, we gotta, yeah.
Yeah.
Can I ask council a question?
Yeah,
Sure.
You can, they're in kind of a dual role because
Okay,
they advise
I
the board,
understand that,
but
but
they also advise.
I'm playing the layperson who has no legal training, so. There's a specific grant to the legislature of the ability to set dates when stuff needs to start or whatever, and the legislature picked April 1 for whatever reason, whenever they did that. I mean, I don't know. Is there anything that allows for a municipality to do anything different but enforce the April 1 date?
There's nothing that I'm aware of.
Okay,
There's no avenue to extend that.
that's what I was fishing for.
Yeah.
Thank you.
And I see nothing just immediately in the copy of the statute. Okay, well, we're still,
The main law court has described April 1st as doom day, as it fixes ownership and tax liability.
Yeah, yeah. It's-
And it has gone on to say that statutes of exemption are to be strictly construed, so all doubts are weighed against the exemption. And that would be the Hebron Academy case. Hebron Academy, Inc. versus Town of Hebron, 2013 law court case.
So something kind of like this, at some point in the past, got up to the law court, and the law court did their thing. And that's what they say.
Yeah, there's nothing in the statute or the case law that I'm aware of that would allow any kind of extension of that.
Okay, that's what I want.
That what it says in Title 36, Section 652, is that do you have 652?
I do.
It says, 36, Section 652, subsection 1, capital L, an organization or institution that desires exemption under this section must file a written application accompanied by written proof of entitlement for each parcel on or before the first day of April in the year in which the exemption is first requested with the assessors of the municipality in which the property would otherwise be taxable. And there's no exception to that anywhere that we're aware of, and no possibility for an extension.
and we have an excerpt of that up here as well.
My turn?
Yeah.
Okay, remember, I'm not looking for an extension. I'm not looking for that. I'm looking for it to be allowed to be backdated. That's what Phil told me to say, Phil Drew. And not, so it's, it's my understanding this board addresses exemptions, not abatements? Or do you only address abatements and not exemptions?
Kind of what we're trying
We're
to,
wrestling with.
kind of trying to figure that out.
Okay,
And that's why I asked the question about a legal basis, because to do what you want us to do,
yeah,
we have to have some legal,
Vehicle.
because the legislature was empowered to create a law, it created a law, it says April 1, and everyone interprets April 1 as April 1.
right,
And then,
Yeah.
is there any other opportunity? And that's what we're, I think, trying to find out if there is, and then we would, the next thing is it applicable? But it
Yeah.
sounds like it's one of those things,
mhm.
I'm afraid.
Well, so is it my understanding that once I have a tax bill, I can file for an abatement? Okay, so this is, and do you hear that, or is that decided at the city level?
I think that's what we're wrestling with subsection 843.
Okay,
It says abatement twice anyway in section 1. And I think we're trying to figure out maybe why it doesn't say exemption, but it says abatement in our enabling statute.
so you as a board do not have the power to
Well,
say,
That's where
That's what we're trying to-
figure out, because if we're convinced we can't do it, then we shouldn't be doing it.
right,
And that's kind of where we,
yeah,
we
you've
have
kind of-
lawyers here.
Could I speak again?
Trying, yes.
Do you want me to?
Sure, I'd say this is a rebuttal, so.
The way that it would operate procedurally is that once you get the tax bill, the taxpayer would file an abatement application with the assessor's office. And then if the assessor then either approves or denies the application, if it is denied, then the taxpayer may appeal the denial by the assessor to the Board of Assessment Review.
Which is us.
Yes,
So
but not now.
Exactly.
And then, we have one other statute you wanted to make, you want to go ahead and?
No, this would be under Title 36, Section 502, which states, all real estate within the state, all personal property residents of the state, and all personal property within the state of persons not residents of the state is subject to taxation on the first day of each April as provided, and the status of all taxpayers and such taxable property must be affixed as of this date. So April 1st is a very important date. There is no variance to that. There's no statute does not direct us to waiver on that. So that's why it's important.
Okay.
Doom date.
So, just kind of summarizing here a little bit, because we've kind of been hopping back and forth, probably more for the board's benefit, but Mr. Burgoyne, to your point, and roundly we've heard, you got to have a vehicle, so to speak, to provide some sort of relief, for example, sought, and at least in these three statutes that we've been kicking around, I don't see that there's a vehicle present there for us to do that. We did also, of course, then hear that there may be an avenue, not yet, we've said that a couple of times, but pursuant to an abatement request, which is referred to in subsection 843, that we've heard also tonight, which kind of deals with our jurisdiction to do so. So getting back to the original question, because we've heard several times from the petitioner or the respondent, right now, we're just trying to determine if this is something actionable, basically, for us, whether we even can address a exemption request. So throwing it out there, are there further questions, discussions about that part? Because I think we're jumping around.
Are the presentations done?
Can I just say one more?
Yeah.
One more thing here. This is in Phil's letter. In my letter dated April 29, 2024, I denied Fresh Start Inc.'s exemption request due solely to missing the filing deadline. So what my concern would be is because it's not exempt, how am I going to be able to get an abatement?
Well, in your opinion, you believe that you.
Whoever talks should be
Oh, I'm
there.
sorry.
And I can address that too, if you want. I mean, whatever you want.
You go right
Yeah, I just, again, the process I already talked about, and it would be requesting an abatement down to 0 based on the exemption, is how you would do it. In my opinion, representing the city's position here, that would be how it would be done. Yeah. Well, I just also mentioned, there's nothing in the law that we can find that would allow any kind of backdating anything to April 1st. So, just wanted to mention that.
So,
But there's no, excuse me, there's no for or against backdating.
The city's position would be that cannot be done legally.
Right.
Okay, so that's, sorry.
okay,
So,
That's what-
So the part.
okay, as long as I can file an abatement.
we'll check to make sure the presentations are
Right,
concluded, and then we
even
probably
though
want to
it's
proceed
not
to some
exempt
sort of decision,
this year.
because I think we're
Ready for a motion.
we're getting there.
Right.
We can talk anytime
Okay.
you'd like to.
That seems eminently proper.
That seems to be the best,
Yes.
but before we move ahead anyway, and I think
Yes.
we're narrowing here anyway, again, excuse the sort of lack of formality, this is a unique circumstance, frankly, that I don't believe in the 15 years or however long I've sat on this board, Mr. Propane, Mr. Burgoyne, a long time with yourself, Mr. Cormier, I can't place this, which is fine, but I think that's part of the reason that we're kind of channeling and trying to find out what options exist anyway. But before we move to some deliberation decision, was there anything else concerning presentations from either the petitioner or respondent? I know several other points were made, sort of going back and forth as we were trying to figure out really what was before us and what options existed. So was there anything that was missed we want to add at this very moment? Okay, perfect. At this point then, pretty much heard it. We've got the dates, we've got some statutes, we had some discussion. I think we're probably at sort of the deliberation phase. So was there anything else on the board side before we try to make some sort of a decision concerning everything that we've heard in terms of applicable statute, authority, method for remedy, the like? I think it is a little bit confusing, given the circumstances. Everyone's digesting, so.
Is it proper to make a motion?
So I think at this point, if, you know, we're confident with what we've heard, we've reviewed applicable statutes, the like, then I think we're at a decision point then, as a board. So
I move to deny the appeal because the board does not have jurisdiction under Title 36, Section 843 to hear appeals of exemption denials.
Okay,
Second?
so it's been moved and seconded that this board deny the request to hear the exemption of the petitioner where this board does not have jurisdiction under Title 36, Section 843. Is there discussion from the board at this time? Okay, seeing none, those in favor of this motion will raise their right hand. I am voting in the affirmative. Down hands those that are opposed. Okay, seeing none. So that motion carries. What will happen is this board will render a decision over the next 7 days that highlights that specific title and section. I would mention, again, given discussion this evening to the petitioner, I would certainly advise you to work with, as you've been doing, the assessor's office and council. It sounds like there's a potential path, so to speak. I also briefly want to commend and thank your organization, you personally, obviously, for your investment in what you've done for the citizenry, for the community of Bangor. Not that ever for a minute that was in question, but I think it goes without saying that we recognize that service and that contribution that you offer. So I just want to put that out there, given the circumstances. Just to the board, we may need to have a very brief conference style meeting just to go over that decision. I'll work with our vice chair to get something drafted. We'll invite comments to the extent possible, run that through the assistant solicitor's office or solicitor's office, just to make sure that we've got the correct formatting, legalese, but just look for that probably early in the week, just so we can get that finalized. So the purpose of tonight's hearing has been satisfied. At this point, I'd entertain a motion to adjourn.
So moved.
Okay, do we have a second?
Second.
Moved and seconded to adjourn. Those in favor signify raising the right hand. I'm voting in the affirmative. Down hands, those opposed. Motion carries. Thank you so much for your time and again for your contributions.
Thank you.
Appreciate that. Hearing is concluded.
Peggy, how much time do we